You know, you can still send the serial killers to prison, and I don't think that that's a bad idea. So that's why the better term, the non-lawyers term, the non-legalese term for jury nullification of law is jury independence. Everybody knows what a jury is, and everybody knows what independence is, and they generally agree with both things. Most people don't know what jury nullification is. It sounds like the jury is being nullified unless you say the full 9-syllable jury nullification of law, which most people won't even say. It's such a mouthful it won't even come out of their mouths. And so mainstream people will never understand that phrase as easily as they understand jury independence, and that you have the right to judge the law, that jury members have the right to judge the law, and that that should be called jury independence. That's the opinion of Clay Conrad, who interestingly wrote a book called Jury Nullification, The Evolution of a Doctrine. He gave it that title just because that's the scholarly lawyer's term, and he wanted it to be viewed as a scholarly book, which it is. It's an amazing book. It goes into immense detail in the history of jury nullification of law, or jury independence, as he suggests it should be called. And everyone should read that book. And that's the other point that I wanted to make, is that democracy is not just elections. It's not just suffrage. Suffrage alone isn't that useful unless it's paired with jury nullification of law, unless it's paired with jury independence activism. And politicians are the best messengers of jury independence because they have legitimacy in the eyes of the electorate. So in all of the people who have been raised by government schools to think that elections constitute a democracy, okay, we should exploit that. The libertarian movement should exploit that appearance of legitimacy instead of saying, gosh darn it, voting legitimizes the politicians. Well, if we get elected as politicians, then we are legitimized, and our message of jury independence is legitimized, which is really a message of civil disobedience combined with jury independence. And so politicians are then in a position to encourage disobedience of unjust laws and to encourage members of their political districts to vote not guilty if they're called to sit on the jury, and to lie to the judge and prosecutor, or not to lie to them, but to serve the higher truth, to serve the higher hierarchical level of truth and honesty, which is to not be eliminated from the jury because you don't answer the voir dire questions right. The voir dire questions themselves are unconstitutional, so you have there's no moral requirement to be honest or tell the truth to a dishonest system. You don't have to tell the Nazis that Anne Frank is hiding in the attic if she is. That would be serving the truth at a low level. You'd be rigidly and honest in a hidebound manner, but you'd be serving a dishonest system. And even Christians, proper Christians, Christians more of the Quaker variety, don't believe that serving a dishonest system is honesty. They don't believe that serving a dishonest system is a moral requirement. So putting jury independence together with electoral participation allows libertarians to occupy the moral high ground in every situation. And occupying the moral high ground is really how voters make decisions anyway. And so it also allows us to occupy the kind of the historical and legal moral high ground. It allows us to present ourselves as pro-American because jury independence is the key part of due process that made America different than Soviet Russia and Nazi Germany and Communist China. All of those nations had no jury trials. It was only what the party wanted, and therefore what the party leadership wanted. The party leadership are the people who successfully sought and obtained power. And it's easier for psychopaths to seek and obtain power because the instant that the system is corrupted, libertarians who don't understand how jury independence goes together with elections to correct an unjust and illegitimate system, those libertarians are at a disadvantage in such a corrupt system because the person who portrays the corrupted system as legitimate allows the voters to feel better about themselves. It allows the voters who voted for the incumbent status quo to say, well, I don't want to view myself as an immoral person, so, I'm not going to vote for the critic of the system. I'm going to vote for the system that I voted for in the previous election and the election before that. So libertarians have to show how voters have been tricked. This is an essential part of every libertarian campaign, and educating the voters about jury independence allows the voter to say, hey, I was tricked, but I was tricked by a complex and very evil system, and therefore I'm going to do things differently from now on. So that's how libertarians use elections to build a libertarian movement. And I should just point out, I'm going to go through another few positive examples where voting for the most libertarian candidate, or the most capitalist, or most abolitionist, or most free soil candidate actually worked out to benefit and dramatically improve and enhance individual freedom itself. Not just the libertarian candidates running, as the so-called agorist critics will suggest, but where it actually expanded individual freedom that is supposedly what anarchists are trying to pursue. There was Dick Randolph in Alaska and his initiative to outlaw state income tax. That succeeded. And what about in cases where initiatives and referenda were thrown out by the courts after they made the ballot? So term limits in Illinois in 2014 was thrown out by the court system, even though the people voted in favor of it. And property tax, well, there was a successful initiative to cap property taxes in California. That's famously what kind of started the initiative and referenda movement in the United States, was Proposition, I think it was Prop 19, limited property taxes in California. And but there have been failed initiatives that have been just tossed out by the fact that the system of initiative and referenda is not the same in every state. It's illegitimate in Illinois, for example. In Illinois, the courts can throw out a voter-approved initiative. And in some states where the courts don't have that unilateral power, and there are some successful initiatives, the courts can still de facto throw it out on technicalities in some ways by claiming that it's unconstitutional. So term limits was thrown out in Illinois in 2014. Jail for judges, judicial accountability in law, was thrown out in Montana and Oregon, I believe, in 2006, in the 2006 election cycle. And spending limits have been thrown out in several states, like Missouri, Montana, and Oregon. So one would say, well, if they can throw it out anyway, it doesn't really matter. Should you even participate? Should you waste your time? Here's a point that I would like to make. The anarchists that I speak with in the libertarian movement, who claim to be Rothbardian anarchists, or principled non-voters, or agorists, followers of Samuel Konkin III, those people usually don't know what the status of the law is in their state. They have no idea whether an initiative will be successful or whether it'll be thrown out, and that you could find all kinds of those people saying if voting made a difference, they would have just made it illegal anyway. In Colorado in 2011, when the state people in the state were pushing an initiative to legalize marijuana. Now, after the fact, none of these anarchists say, well, I think it would be better that all the innocent people went to prison. But that's what the initiative accomplished. It kept all those innocent people out of prison. It successfully stands in the way of marijuana prosecutions in Colorado now, and has for several years now. So think of all the innocent people who would have gone to prison and had their lives completely ruined for a nonviolent so-called marijuana offense. That's not really an offense of any kind because there's no injury and no intent to injure another human being. So therefore, constitutionally, the drug war is already illegal, and that's another thing that libertarians can point out when they run for office, is that under Article 1, Section 9 of the Constitution, technically no regulatory offense or drug offense has any force of law, of criminal, under the criminal common law, which is the only legitimate law in the United States, because there's no injury and no intent to injure another person. And of course the prosecutors will claim all of society is harmed, but when they do that, they're essentially transitioning from a constitutional argument into a Marxist argument,